Yeah, very good morning, all of you. Let me take the attendance. Drishti Verma, Hemant Kumar, Kartikeyan Sharma, Parth Narendra Bhai,
Yes, sir.
Prakash Chaudhary, Pushpendra Pal Singh, Rakesh Raika, Ravi Raman,
Yes,
Sangya
sir.
Gupta, and Arya Dikshit. So
Prakash Chaudhary
today
present,
we
sir.
let us just start with the presentation directly. So yesterday we studied about the uh, uh, yesterday we studied about certain exception to the rule of namo dat coup non-habit, and along with that we have also studied when how to transfer the title and how to go for delivery of the goods. Now further today we will be doing because this is the 24th session, so we will be doing two things, session 24 and 25th, so that within this week I will be able to finish off with the, and you will all be able to finish off with the Sale of Goods Act. So performance of the contract of sale we will be going with. Okay, along with the rights of the unpaid seller. Then what happens when the seller is unpaid? Seller has sold the goods. The transfer of property happens as soon as the goods are transferred from. You can say the property is transferred from the seller to the buyer. But at the same time, if the delivery has not been taken, so delivery is one of the thing which is again very important, and who will be responsible for such delivery, that is to be discussed. Okay, so let us now proceed further with the performance of contract of sale and the delivery of the goods. So yes. So performance of the contract of sale is given under section 31 to 44 of the this Sale of Goods Act. Okay. So definition of delivery. What is a delivery actually? Delivery means a voluntary transfer of the position from one person to another. Just a moment. Yeah. So in this chapter we will study something more about the delivery. So delivery, you know very well that what delivery means. So it is a voluntary transfer of the position. So one person has to transfer the position to another. So yesterday we studied one more thing, that the transfer of ownership, along with the transfer of ownership there has to be an immediate delivery. It is always good to have an immediate delivery as soon as the goods are transferred. Otherwise, a person with whose custody the goods will be different from the person who has been transferred the goods, or the ownership and delivery will be different, and in that case more disputes happen. So it is always recommended that the goods should be delivered as soon as the position has transferred. This is my personal that also, and the legal advice to everyone is the same one, that if you have transfer the goods, please take the delivery as soon as possible. The goods should be in the possession of the person whom it belongs to. Okay, so that what is the position of the goods, or you can say the delivery of the goods from the seller to the buyer should happen accordingly. Okay, so the rules regarding delivery and the process of delivery, we will be studying this, and what are the various types of deliveries we will be studying today. So thus, if the position is taken through unfair means, so it is a voluntary transfer. That section 2 says delivery means the voluntary transfer. But if the position is taken through the unfair means, that is no delivery of goods, then there is no delivery of goods. It will be means deemed as if delivery has not been taken or delivery has not been done. So delivery of goods sold may be by doing anything which the parties agree shall be treated as a delivery, or putting the goods in the possession of the buyer or any other person authorized to hold the same on the behalf of the buyer, then it is called the delivery. So section 31 is regarding the duty of seller and the buyer. So it is a duty of seller to deliver the goods and the buyer to accept the delivery and pay for them. So in accordance with the terms of the contract of sale. Further, the most another important thing is these all must happen in accordance with the terms of the contract of sale. Okay, so there can be constructive delivery, there can be actual delivery. Delivery can also happen, and there are symbolic links. So three types of deliveries we have already studied when we were discussing the definitions. Okay, so the elaboration of those will come over here. So payment and delivery are concurrent conditions. Unless and otherwise agreed, the delivery of the goods and the payment of the price are concurrent, means these should happen hand in hand. वो कहते हैं ना एक हाथ ले और एक हाथ दे. So these एक हाथ ले and एक हाथ दे is actually the payment and the delivery happening in concurrently. So that is to say that the seller should be ready and willing to give the position of the goods to the buyer in exchange of the price, and the buyer shall be ready and willing to pay the price in exchange of the position of the good. So one should give the goods and other should give the price, and it should happen hand in hand, and both the things must be voluntarily, or you can say it is a voluntary transfer, or it's a voluntary and willing transfer by one person to another. Okay. Next is the rules regarding delivery, or you can say how the delivery happens. So there are sometimes there is a part delivery also. Okay, so part buyer has to apply for the delivery, and the place of delivery is to be determined, time of delivery is to be determined. So goods in, if the goods are in possession of the third party, then there are certain other things. What will happen regarding the expenses of the delivery of the wrong quantity? If the wrong quantity is delivered, then what are the consequences of it? Okay, then what about the, if the delivery is in installments? So delivery as to courier or war finger means it is on the behalf of someone, you are on the behalf of the buyer, you are delivering it to the couriers. For example, the goods have to be transferred from one place to another, and it has to be transferred to the courier. So courier will take it, or war finger will take it up, or war finger will keep it in his custody. Okay, so deterioration during the transits, what will happen if the goods get deteriorated during the transit, and what are the buyer rights to examine the goods? So in these sequence and in this process we will be able to understand the rules regarding the delivery. So first is a delivery which is given under section 33. So delivery of the goods sold may be made by doing anything which the parties agree shall be treated as a delivery, for which has the effect of putting the goods in the possession, sir, in the possession of the buyer or of any person authorized to hold them on his behalf. Next is the part of effect of the part deal. What happens? So delivery is something which is a complete delivery. Okay, what happens if the part delivery is there? A delivery of the part of the goods in progress of the delivery of the whole has the same effect for the purpose of the passing the property in such goods as a delivery of the whole. Okay, but a delivery of part of the goods with the intention of serving it from the whole does not operate as a delivery of the remainder. Okay, so this is what it is. Okay, so when part delivery happens, when the goods are delivered at part, the progress of the whole delivery will be having the same effect. Means it is as if you are taking the delivery of the full item. Okay, for the purpose of passing the property. So to the extent the delivery has happened, sometimes it is given in the terms and conditions that the delivery and the possession will go hand in hand. So the things will be delivered will only be called as a delivery in possession, and only those things will be considered as a purchase one which are delivered. But a delivery of a part of goods with the intention to severing it from the whole does not operate as a delivery of the remainder. So if the part delivery is to be done, then it should be in sequence with the original delivery. Okay, so if for example there is a delivery of suppose 100 bales of cotton to be done, and the person and it was decided that the 100 bales of cotton will be delivered in the installment of 25 each. So what happens, and it was further decided that when the delivery of goods will happen, then the amount of the this particular goods will be paid. So the seller delivered two installments, 25 of 25 each, and then afterwards buyer told that okay, now I will not take delivery in the way it is, so I will take the delivery after 1 month. Okay, so now here the contract may come to an end. So the remaining delivery will not be a part of this delivery. Then there will be a separate contract or separate thing for the remaining item to be done. Okay, so that is a part effect of the part deal. For example, certain goods lying at the war finger were sold in a lot. The seller instructed the war finger to deliver them to the buyer who had paid for them, and the buyer thereafter accepted them and took away the part. Hence there was delivery of the whole. Now here the delivery is of the whole, but the example which I have given you is the example of a part delivery. Next is buyer apply for the delivery. Apart from any express contract, the seller of the goods is not bound to deliver them until the buyer applies or buyer asks for the delivery. So it is a duty of buyer who has to ask for the delivery, and then he should ask as soon as, because again he has actually purchased the goods, he has paid the price for it, so he should be having a pain to take the delivery of the goods. Okay, and if some unreasonable delay has happened from his side, so he will be responsible for that delay, not the seller. Okay. Next is the place of delivery. So whether it is for the buyer to take the position of the goods or for the seller to send them to the buyer is a question depending in each case on the contract express or implied between the parties. Okay, so apart from any such contract, goods sold are to be delivered at a place at which they are at the time of sale. So now this is very important. So if there is anything contrary to the contract, the delivery will happen at the place where the goods are existing, and the goods agreed to be sold are to be delivered at the place where they are at the time of agreement to sale. So wheresoever is now here, if you see, the goods are following the agreement. Okay, so it is following the agreement. For example, the goods are at, suppose you want to take up this Samsung Galaxy Note 20 Ultra, and you have gone to a shop where you want to take. So where the delivery will happen? Delivery will happen where you will pay and take the delivery, means at the time of sale where the goods are existing. So the goods are existing with the vendor at the time of sale. So delivery will also happen at that there itself. Okay. So and further, if there is some agreement to sell, so goods are agreed to be sold, to be delivered at the place where they are at the time of agreement to sell. So where wherever the goods are kept at the time of agreement to sell also, then it will be sold from there itself. So if not, then in existence at a place which they are manufactured or produced. Okay, so if there is some agreement to sell, so there are two things: whether the goods are lying, if they are existing goods, they will be lying at certain place for which there is an agreement to sell. So that will be called as a place of delivery. Or if the goods are not, or it is a future goods. Okay, so the where it will be manufactured will be the place at which it will be delivered. For example, a person wants to get a gate, you can say a fabrication. He went to a fabricator shop and he wants a gate to be manufactured, to be put in the front of his own house. Okay, so what will be the delivery? So this is not in existence. You have just placed the order. The things will be manufactured or produced. So the date, the place of delivery will be the manufactured or the place where the goods will be produced or manufactured as such. Okay, so accordingly the things will go on. Okay. Next is your time of delivery. Again, very important. Okay, so where under the contract of sale, seller is bound to send the goods to the buyer, but no time for sending them is fixed. The seller is bound to send them within the reasonable time. Okay, so what is reasonable time will be decided by the court afterwards. Or suppose, for example, you went to purchase a mobile. Okay, so mobile is to be delivered as soon as you have, paid the money. So even or otherwise, the seller may tell, okay, my mobile is not with me now because you have asked for such an expensive piece. We do not keep the stock, but it will take 1 hour for my vendor to just for my boy to just bring it from the place where it is lying. So accordingly, the things will happen, and the time of delivery will be after 1 hour because it is being fixed between both the parties. Or otherwise, if it is not fixed, then the person has made the payment and the seller is not giving the goods, he can actually tell him, okay, you return my payment, I do not want it from you. So in this span of time, because 1 hour is not a reasonable time for normally 1 hour is not a normally reasonable time for a person to bring the goods kept somewhere, because he can tell that you should have told me before that goods are not with you. It means the person is not carrying the goods. That's why his cost will be reduced. So he can ask for bargaining of the cost also, and he can even resign the contract if the goods are not delivered in the reasonable time. So another important thing, for example, this goods, when the goods are to be manufactured or produced, then and that is on order, then it will take some reasonable time to be, and that time at that moment of entering into agreement can be fixed. Or if the no time is fixed, then again it has to be a reasonable time. For example, a fabricator normally will deliver you within 10 days. Okay, so 10 days or 15 days will be the reasonable time. And if the things goes in dispute, then court will decide what is a reasonable time and will act accordingly. Okay. So next is regarding goods in possession of the third party. So where the goods at the time of sale are in possession of third person, there is no delivery unless and until such third person acknowledges to the buyer that he holds the goods on his behalf. For example, this war finger, for example, the courier. So a person has given a delivery to the courier and the courier is now holding, previously was holding on the behalf of the seller. Now he is holding the goods on the behalf of the buyer, and he should actually acknowledge that, okay, now I'm having this on the behalf of the buyer, where to come and deliver the goods. So provided that nothing in this section shall affect the operation of the issue of transfer of any document. So there is no issue or transfer of any document to the title of the goods. So title of the goods has already been done, but this is only the possession of the goods which is being considered over here in under section 36(3). Next is time for tender of delivery. So demand or the tender of delivery may be treated as ineffectual unless made at a reasonable hour. And sometimes it may happen, okay, at night at 1 a.m. somebody approaches, okay, the day has come for the delivery because the day changes at night 12 o'clock. So now I am eligible for the delivery. I am standing downside your house. Please deliver me the goods which we have, for which we have contracted. Okay, so now over here the goods cannot be delivered because it is a totally unreasonable time for delivery of the goods as such. So it has to be decided. If not decided, then the reasonable hour is actually a question of fact. Next is a expenses for the delivery. So expenses for and of incidental to putting the goods into a delivery state must be borne by the seller in absence of the contract to the contrary. So normally what happens, it is a duty of the seller to bear the expense for the delivery of the goods. It is a expense for the delivery of the goods, not the expense of transportation of goods. Okay. So delivery of the goods may comprise of, packing and other things before the goods goes in the possession of the purchaser or the buyer. So before that, all the expenses are to be borne by the seller. But sometimes it also happens that the transport or the delivery expenses includes the local transport. So local transport can be included in it, provided it is so decided before entering into a contract with the buyer for purchase of sale. Suppose, for example, I purchase 2 coolers for the summers. Okay, so who will just deliver those 2 coolers at my home? So it totally depends on that how much price you are paying. So whenever you are bargaining for the price, you can ask, okay, I will take the delivery in my own car or in my own vehicle. So you reduce the amount which you have to pay to the person for the transfer. So this can also happen. Okay. For example, just for delivery, there is a very good example of Amazon. So Amazon and Flipkart, they are delivering the goods at the doorstep. So it is written over there for the goods less than rupees 500, the delivery charge will be borne by the person who is asking for the goods. But if you are having this so-called Prime membership or something like that, then the goods will be delivered to you free of cost, even if it is less than rupees 500, and it will be delivered free of cost at your doorstep. So that is something which is expressly given. Okay. So next is delivery of wrong quantity. What happens when the seller delivers to the buyer the quantity of goods less than he has contracted for the sale? The buyer may reject them, but if the buyer accept the goods or deliver, he shall pay for them at the contracted rate. Okay, so it is all the at the discretion of the buyer. If he is accepting the goods, then the goods will be, because either he should resign the contract or turn off all the things, and he can reject the delivery of the entire. But if he is receiving something in part, then he will not reduce the price per quantity. So he has to take the delivery and he has to just buy them on the price which is contracted for. Okay, so where the seller delivers to the buyer a quantity of goods larger than he has contracted to sell, the buyer may accept the goods included in the contract and reject the less, or he may reject the whole. But if the buyer accepts the whole of the goods delivered, he shall pay for them at the contracted rate. It is not like that the seller has sent something extra to them, so that has become a free of cost. So it will not happen as a free of cost as such. Okay, so where he is accepting the goods more than what he has ordered and seller has sent more, so he has to pay extra for the more which he has got. Okay, otherwise there will be unjust enrichment. So where the seller delivers to buyer the goods he contracted to sell mixed with the goods of a different description not included in the contract, the buyer may accept the goods which are in accordance with the contract and reject or may reject the whole. Okay, so this is what, because he has not asked for certain things and buyer has by mistake sent him certain things. So here he cannot, even if he wants now, he cannot accept the whole lot which comprise of the mix of the goods which he ordered and which he didn't order. So which he didn't order is a totally mistake, and anything by mistake is void as per the agreement. So either what he can do, he can either accept the part and reject the remaining, or he may reject the entire goods, but he cannot accept the entire thing until and unless he actually again makes a contract, or he again telephones or informs the seller that you have given me something extra, so what should I do with it? Do you want to sell it to me or whatsoever? So if the seller says that okay, as it has reached you by mistake, now the mistake has been rectified, if you want to purchase it, please purchase it, go ahead, no problem. So this will be a separate contract, different from what he has done before for the quantity which he has contracted for. The provisions of these sections are subject to any usage, trade, special agreement of the course dealing in the parties. No problem. So A agrees to sell 100 quintals of wheat to B at 1000 rupees per quintal. So A delivers 1100 quintals. B may reject the whole lot or accept only 1000 quintals and reject the rest, accept the whole lot and pay for them. So here the quantity is more, but it is not a mix of any other thing which he has not ordered. The quantity is more than what he has ordered, so he may accept paying for the whole lot. Okay. So that's the next rule is regarding the installment deliveries. So unless otherwise agreed, the buyer is not bound to accept the deliveries in installment. So buyer has to take the deliveries in one lot only. This is by default, until unless it is agreed that the seller will give the delivery in installment or buyer will receive the delivery in installment. So the rights and the liabilities in case of the delivery by installment and payment thereon may be determined by the parties in the contract. Both the parties can determine what will be the terms and conditions of the delivery. Next is delivery to the courier. So subject to the terms of the contract, the delivery of the goods to the courier for transmission of the goods from the seller to buyer is prima facie deemed to be a delivery to the buyer only. So here the transporter will act as an agent of the buyer and will accept the goods, and the delivery will happen to this transporter on the behalf of the buyer, and it will be as good as that goods are delivered to the buyer only. Okay. Next is what happens if the goods get deteriorated in transit. So where the goods are delivered at a distant place, the liability for deterioration necessarily incidental to the course of transit will fall on the buyer, though the seller agrees to deliver at his own risk. Okay, so it will fall on the buyer itself because it is a distant place. So buyer has to actually think of that whether the goods should not get deteriorated while on the way. So if he is ordering such a goods from such a distance, he has to consider it that the goods must reach to him in a good condition, or whatever deterioration happens, it is buyer has to bear those deterioration. Okay. Example, P sold to Q certain quantity of iron rods, which was to be sent by in a proper vessel. So it was rusted before it reached the buyer. The rust of the rod was so minimal and was not affecting the merchantable quality, and the deterioration was not necessarily incidental to the transmission. It was held that Q was bound to accept the goods. Actually, now here the P has sold the goods to Q. Now that rest will happen because on the way, 8-10 दिन में what will happen? Some rain will be there and something, and the rust is just a minimal one. That it has actually rusted only from the beginning, and the goods has as a whole reached to him in full quantities. The buyer has to accept it all. Okay. Next is regarding buyer's right to examine the goods, where the goods are delivered to the buyer who has not previously examined him. He is entitled to reasonable opportunity for examining them in order to ascertain whether they are in conformity with the contract or not. Unless otherwise agreed, seller is bound on request to afford the buyer a reasonable opportunity to examine the goods. So what happens if the goods are from, are being transferred from very far away? So it should match with the description, not with the sample. So but at the same time, if the buyer wants to come by air, by flight, or by whatsoever means and want to inspect the goods, the seller cannot refuse the inspection of the goods to the buyer because he is paying the price for it. Okay. Next are the rules regarding the acceptance of the delivery of the goods. So buyer is deemed to have accepted the goods when he intimates to the seller that he has accepted them, or when the goods have been delivered to him and he does any act in relation to them which is inconsistent with the ownership of the seller, or when after the lapse of the reasonable time he retained the goods without intimating to the seller that he has rejected them. Okay, so this is the most important thing. So acceptance is deemed to take place when the buyer intimates to the seller that he has accepted the goods, number one. Secondly, does any act to the goods which is inconsistent with the ownership of the seller. It means, suppose for example, he has actually pledged the goods or he has sold the goods to someone else, so it will be deemed that he has accepted the goods. Okay, retains the goods after the lapse of the reasonable time. For example, the sale is on sale or return basis. So beyond the reasonable time, he has actually retained the goods, and because he has retained the goods beyond that time, then it will be called as a, it as if he has purchased the goods. And also he has retained the goods without intimating the seller that he has rejected them. So he will keep on retaining the goods. It means he has accepted the goods. So these are rules regarding the acceptance. We have studied it before also. So when buyer not bound to return the rejected goods, unless and otherwise agreed, where the goods are delivered to the buyer and he refuses to accept them, having the right to do so, he is not bound to return them to the seller. But it is sufficient if he intimates to the seller that he refuses to accept. Now there is no duty of the buyer until and unless provided. The first line is this: unless otherwise agreed. If it is so, then he has to refund. Suppose, for example, I just asked the person to just give me a test ride and deliver and give me the goods for on trial basis for 1 or 2 days. And then after 2 days, I told him that he called me that, okay, do you accept the goods? My saying this is sufficient that I do not accept the goods. Now it is his duty to take away his car from my house because I have already rejected it. Okay, so his buyer is not bound to return the rejected goods, but the seller will take away his goods until and unless it is agreed. Okay, but if the goods are something which are related in the way that the buyer has to take it back, give it back, then the buyer should give it back. Okay, next is liability of the buyer for neglecting or refusing the delivery of the goods. So when the seller is ready and willing to deliver the goods and requests the buyer to take the delivery, and the buyer does not within a reasonable time after such request takes the delivery of the goods, he is liable to the seller for any loss occasioned by his neglect or refusal to take the delivery, and also for a reasonable charge for the care and the custody. Because why? This can't you see there is something called a breach of contract over here? There is something breach of contract over here, that even after contracting, the buyer is refusing the delivery of the goods. Okay, so these all things he has to pay, he has to bear. Okay, because it is all similar to the contract of the what you call is this is a breach of the contract. Further provided, nothing in this section shall affect the rights of the seller where the neglect or refusal of the buyer to take delivery amounts to repudiation of the contract. So seller can repudiate the contract also and file a suit against him for the damages which he has caused. Okay, so it is totally will be a you can say a breach of contract. Okay, so summary is there that how we have gone with it. Okay, next is your unpaid seller. So what is the unpaid seller? So unpaid seller is the seller who has not been paid for the goods which he has sold. So now he is having the two rights. So he is having right against the goods, and if he is having rights against the buyer. So three rights are there against the buyer. He can suit for the price of the goods, number one. He can suit for the damages, and he can suit for the interest. So these three rights he is having, which can be enforced in the court of law. Against good, what he can do, if the property in the goods has passed to the buyer, then he is having certain rights. And if the property of goods has not passed to the buyer, then also he has. If the property in the goods means the sale deed has happened, So what he can do, he can only exercise lien on the goods. And if the goods are in transit, because the property in the goods has transferred from seller to buyer, and the buyer has not paid the seller. So another thing what he can do is he can stop the good in transit and further resell the goods to someone else. So these are the three rights which he can. First of all, he will exercise lien if the goods are in his possession. Secondly, if the goods are not in his possession but is in transit, he will just stop that carriage in transit and then resell the goods in both the case, whether the goods are with him or he has found the goods on the way. Okay. Now, if the property in the goods has not passed to the buyer, so he can withhold the delivery, or you can say he will not, because the property in goods has not yet passed. Property in goods has not yet passed. Only agreement has done. Agreement is done, but property in the goods has not has passed. Now the goods are in his position. He can withhold with the delivery, and rest of the rights, lien, stoppage and transfer and resale, are same as that of the as if the property has been passed. So it is very simple. So let's just go for this. So a contract comprised of the reciprocal promises. In the contract of sale, if the seller is under an obligation to deliver the goods, buyer has to pay for it. Okay. And in case if the buyer fails or refuses to pay, the seller as an unpaid seller shall have certain rights which we have just now discussed. Okay. So according to section 45(1) of the Sale of Goods Act 1930, the seller of the goods is deemed to be an unpaid seller when the whole of the price has not been paid or tendered and the seller has an immediate right of action for the price. Secondly, when the bills of exchange or a negotiable instrument which has been received as a conditional payment and the condition on which it was received has not been fulfilled by reason of the dishonor of the instrument or otherwise. Okay. Next is the term seller. Here includes any person who is in the position of a seller, as for instance an agent of the seller to whom the bill of lading has been endorsed, or consignor or agent who has himself paid or is directly responsible for the price. Okay. So term who is the seller over here? Seller includes a person who is in the position of the seller. So even the agent of the seller will also be called as a seller. So an agent can also be a carrier. He can also be a transporter because he is also working on the behalf of the seller. So an agent of the seller to whom the bill of lading has been endorsed, or a consignor or an agent as himself paid, or any directly responsible person for the price will be treated as a seller in this. So the scope of the seller is very wide. Okay, for example, X sold certain goods to Y for rupees 50,000. Y paid rupees 40,000 but fails to pay the balance. So X is an unpaid seller because part payment has not been made. For example, 2. P has sold some goods to R for rupees 60,000 and received a check for the full price. On presentment of the check got dishonored. So P is an unpaid seller. So in this case, the unpaid seller will be there. So I hope the fundamental regarding unpaid seller is clear to you. The price in full must be received by the seller. Then only he will not be called unpaid seller. Otherwise, he will be called a seller, unpaid seller only, even if a part is remaining. So unpaid sellers' rights are given under section 46, subject to the provision of this act and any other law for timing in force, notwithstanding that the property in the goods may have passed to the buyer. The unpaid seller is even if the property has been passed, still the seller is right. I have told you that if the property passed, the ownership also passed. But even if the ownership is passed and the seller is not yet paid fully, he will be having certain rights, and it is by implication of the law he can exercise a lien on the goods and the price he is in possession, and in case of the insolvency of buyer, a right of stopping the goods in transit, and after he has parted with the possession of them, the right to resale as limited by the act, because again there is limitation for this under subsection 1. So where the property in the goods has not passed to the buyer, the unpaid seller has, in addition to his other remedies, the right of withholding the delivery, similar to as a coextensive with the right of lien and stoppage in transit where the property has passed. So it is completely been elaborated. See, section 46 is completely elaborated over here as such. Okay, so what will happen if it is it is the property has passed, what will happen if it is not passed? He can sue for the price damages and the interest. Okay, we will just study it. So unpaid seller has been expressly given a right against the goods as well as the buyer personally, which are discussed as under. First is the right of the unpaid seller against the goods. The right of the unpaid seller against the goods can be categorized under two headings: against the goods where the property has passed and where property has yet to pass or not pass. So seller's lien. So according to subsection 1 of section 47, subject to the provisions of the Act, the unpaid seller of the goods who is in possession of them is entitled to retain the possession of them until the payment or the tender of the price of the price in the following cases, namely where the goods have been sold without any stipulation to of the credit, the goods have been sold on credit but the terms of credit has expired, and where the buyer becomes insolvent. So in these three conditions, if the goods are still in the possession of the buyer, he can exercise lien on it. He cannot let anyone take away the goods from him even if the property in the same has been passed. Okay, but if there is a credit, the terms is on credit, he may not be called as an unpaid seller because the terms of the contract is that the contract that the price will be paid partly now and partly in installments. Okay, and secondly, if the goods have been sold on credit but the terms of credit has expired. Okay, now the terms of credit has expired, for example, in the hire purchase contract. So in the hire purchase contract, what happens? Until and unless the last installment is paid, it is deemed that the goods is on hire, that is goods is on rent. So each and every installment will be considered as rent until and unless the last installment is paid. When the last installment is paid and a letter is taken that now it is free from all the things will accordingly happen. Okay, next is according to subsection 2, the seller may exercise his right of lien, not withholding that he is in possession of the goods as an agent or a bailiff for the buyer. This is very simple. Okay. Next is right to stoppage in transit. So there are certain rights of the seller to stop the goods in transit where the goods are already in transit where it is going on. So there are certain rights to that also, which is given in section 50 to 52. Subject to the provisions of this act, when the buyer of the goods becomes insolvent, the unpaid seller who has parted with the possession of the goods has the right of stopping them in the transit. That is to say, he may resume the possession of the goods as long as they are in course of transit. So a seller can actually, even if the goods he has released the goods. He has released the goods and the goods are in transit but has not reached the buyer. So he is having all the rights to stop the goods in transit and take the possession of the goods as such. Next is right to resale. So right to resale is a very valuable right given to an unpaid seller because this is a right which will ensure that he has got his money, he will get his money back. So in the absence of this right, unpaid sellers' other rights against the goods of lien stoppage would have no meaning at all. Okay, because these rights only entitle these right only entitle unpaid seller to retain the goods until he is paid. So until and unless he is paid off, all the rights are useless. Right to exercise lien, right to stoppage of goods, these all will be useless if he is not able to realize the amount which he is supposed to. Okay. Further, the unpaid seller can exercise the right to resell the goods under the following conditions. What are the conditions? Where the goods are of perishable in nature. Wow. If the goods are of perishable in nature, what will happen? In such a case, buyer need not to be informed for the intention of resale. Why? Because the goods will perish. The goods will deteriorate and there will be no existence of goods which he has actually sold. So he is having right to resell the goods immediately. Where he gives a notice to the buyer of his intention to resell of the goods. If after receipt of such notice, the buyer fails within a reasonable time to pay for a tender price, the seller may resell the goods. For example, the seller has captured the goods in transit and the buyer has actually he has been informed that your goods are with me. Now you pay up for these goods, otherwise I will sell it off. So if the buyer doesn't pays in the reasonable time, then the goods may be sold off. Okay, so it may be noted in such a case on the resale of the goods, the seller is also entitled to recover the difference between the contract price and suppose the price is the goods at which the seller has sold is at the less price because the half of the goods have perished. So now he will be having all the right to recover that price from the seller. Next is retain the profit if the seller resale price is higher than the contract price. Now, because the buyer has made a default and the seller has sold the price at higher than the price at which he has sold before, so he is having all the right to retain the profits of the resale. He is not at all bound to share these profits with the seller because default has been made by the default has been made by the buyer. So the seller is having no obligation to share the profit with the buyer at all. So it may also be noted that the seller can recover the damages and retain the profits only when the goods are resold after giving a notice. It is very important the buyer must be given a notice. Thus, if the goods are resold by the seller without giving a notice to the buyer, the seller cannot recover the loss suffered on resale. Moreover, if any profit of resale is there, he has to give it to the original buyer because he has not given such notice. Because without notice, if he is doing, it means because why? The goods, the property in the goods has already transferred to someone. Now he is an unpaid seller. Now he has to inform that seller, okay, I'm going to resell your goods because the goods are actually belong to the buyer now. Okay, so buyer must be informed. He must be given a reasonable time. If he doesn't respond, then these are the consequences which can be done. So where an unpaid seller who has exercised his right of lien or stoppage in transit resell the goods. Okay, so the subsequent buyer acquires a good title. What will happen? The subsequent buyer will acquire a good title thereof as against the original buyer, despite the fact that the notice of resale has been given or not. So whether the notice of resale has been given, the new buyer will always get the good title. What is the effect of notice? Effect of notice is that if the notice is given, the loss suffered can be recovered and the profit can be kept. But if no notice is given, then the loss suffered has to be borne by the seller and he may have to pay the extra amount which he has gained after the resale to the buyer if notice is not given. Okay, so this is the effect of the notice. So a resale by a seller where a right of resale is expressly reserved in the contract of sale. Sometimes it is expressly agreed between the seller and the buyer that in case the buyer makes a default in the payment of the price, the seller will resell the goods to some other person. In such a case, notice is not required. Okay, in such a case, there is a reservation. So he is having all the, you can say, right to resell the goods to someone. It may be noted in such case the seller is not required to give any notice also. Next is where the property in the good has not passed to the buyer. The unpaid seller has, in addition to the remedies, one more thing which is called the right of withholding the delivery. So he can withhold the delivery, or he can actually, you can say, it is something which is quasi-lien. Quasi-lien means it is implied that the property which is already in the possession of the buyer, so he will not give that because the property is still in the position of the seller only. So if the property is in the possession of the seller, so he can, what he can do, he can withhold the delivery. He will not further the delivery to the buyer. So rights of an unpaid seller against the buyer. Now this is personally against the buyer. So unpaid seller against the buyer can enforce certain right against the goods as well as against the buyer personally, which we have seen in the table which I have shown you in the beginning. So that table has to be prepared by all of you when this question is asked, and this is a very important question. I'm telling you. So rights of an unpaid seller against the buyer are otherwise known as seller's remedy for breach of the contract of sale. The rights of the seller against the buyer personally are called right in person, and or it is called just in rem. Okay, right in person is called just in rem. Just in personam. And in addition to the right against the goods. So it is just in personam and like also just in rem. So right against the buyer are as follows. He can file a suit against the buyer for the price. First of all, this is the only thing which one should do, where under a contract of sale, property in the goods has passed to the buyer, and the buyer wrongfully neglects or refuses to pay for the goods according to the terms of the contract. The seller may file a suit against him for the price under section 55(1). So where under the contract of the sale, the price is payable on a day certain, irrespective of the delivery. Means there is certain day on which price is to be paid, irrespective of the delivery. The buyer wrongfully neglects or refuses to pay the price. The seller may sue him for the price, although the property of the goods is not passed. The goods have been appropriated to the contract. So even if the seller is having the possession of the goods, he must file a suit against the seller for the price of the goods, because the property is there and there is a and he is having the possession of the same, but the property actually belongs to him. So it may not have passed, but still he can file a suit for the price. Next is suit for the damages for the non-acceptance, where the buyer has wrongfully neglected or refuses to accept or and pay the goods, or the instrument which he has paid has got bounced or whatever. So seller may be actually having, he can file a suit against him for damages for non-acceptance of the goods. As regard to measure of damages, section 73 of the Indian Contract Act 1872 applies that whatsoever will be the damages, accordingly damages will be paid. So it can be vindictive damages, it can be actual damages. Okay. Next is repudiation of contract before the due date, where the buyer repudiates or before the date has come. So this is something which is called anticipatory breach. So where the buyer repudiates the contract before the date of delivery, the seller may treat the contract as a rescinded and sue for the damages for such breach. So this is known as the rule of anticipatory breach of contract. Next is suit for the damages, where there is a specific agreement. Now here this damages can be claimed only if there is a specific agreement for the same. So where there is a specific agreement regarding between the seller and the buyer, so as to interest on the price of the goods from the date on which the payment. So this sometimes is written on the bill itself, that 21% interest will be charged if there is a delay in the delivery. So when you get the invoice, it is written on that invoice itself. Okay, so there is a agreement between the buyer and seller that whatsoever delay will happen, so the seller will be able to recover the interest from the buyer if there is any delay. However, if there is no specific agreement in this effect, the seller may charge interest on the price when it becomes due from such date as he may notify to the buyer at a reasonable rate. Okay, so this is what it is. Next, in absence of the contract to the contrary, the court may award the interest. So if the things goes in court, the court may award the appropriate interest at which the rate at which the court thinks, and the amount and on the price of the goods from the date of tender of the goods and from the date at which the actual price was payable. So the court will decide the time limit and the date also regarding the payment of the interest. So that's all about your contract of sale, or you can say that is the Sale of Goods Act 1930 is over. Okay, and we have the time is also over. So let me take the attendance and we'll set you free afterwards. Okay. Yeah. So attendance, please. Chandresh Kumar Sigar, Drishti Verma, Gautam Godra, Harshit Kumawat, Hemant Kumar Sati, Kartik Rajput, Kartikeyan Sharma, Khushi Shekhawat, Laksharaj.
Present, sir.
Yes, sir.
Laksharaj Singh, why two names are coming? Lakshay Raj Singh and Laksharaj Singh. Manan Goyal, Mukul Swami, Nandini Khandelwal, Parth Narendra Bhai, Prakash Chaudhary, Rohit Yadav, Upendra Pal, Rahul Javaria, Rakesh Raika, Ravi Raman, Modi, Sandeep Singh, Shaurya Dixit, Soumya Deepa, Tarush Mudgal,
Present,
and
sir.
Kirthak.
Present, sir.
Shaurya, congratulations. There is maximum attendance in the class today.
Yes, sir.
So guys, there is one announcement for you. We will be having a quiz again because you people have not performed well in that. So I will be having all the 4 quizzes will be held tomorrow from 1 p.m. to 2 p.m. Okay, those who want to appear, they can appear, and those who will not appear, I will assume the marks, the before marks only. Okay, but I'm telling you, you guys have not performed well in those. So let us just make it compulsory for everyone to appear in tomorrow's quiz. And one more thing, because now meanwhile, by the time many people have already settled down from transferring and jumping from one section to another. Okay, so I hope you all have settled down. So tomorrow at 1 o'clock, from 1 o'clock to 2 o'clock, I will be having all the 4 quizzes scheduled for you. Is there any problem in that? You can just tell me now.
No, sir.
Fine. So make sure that everyone should appear in the quiz. And now let me tell you one more thing. You have to enter only by your official ID. I will not accept even a single person who will be entering from, and rather you will not be allowed to enter with the unofficial IDs. Okay, so there will be a link which will be shared on the Teams only. You have to come on Teams, you have to click the link and you have to appear for the quiz. Otherwise, you will not be able to appear. And this will be the rule for the future also. Is it clear to everyone?
Yes, sir. Sir,
Fine.
most of the students are not added to the teams yet, and I don't know why. But
You please tell me the names who are not added. I will add them today.
okay, sir.
Sure, get it done today itself because tomorrow is the quiz, and if they have not got themselves added, then it is their problem. I do not. And one more thing, please synchronize your Google group also along with the people in the teams. Okay, sure. Please
Right.
make a note of it. You have to do it by today itself because tomorrow we will be having quiz from 1 to 1 to 2. 4 quizzes will happen side by side within 10 minutes, and you will get 5 minutes break in between. Is that okay?
Yes, sir.
Fine then. Thank you guys. Thanks for your
Thank you, sir.
participation in
Thank
the
you,
class today. This is over, and then afterwards we'll be having some revision of this also, and then we will proceed further with the quiz of the Sale of Goods Act. So at present we will be having quiz only of the Contract Act, which I have taken before also, but I have to take it again, right? So this quiz may happen maybe on Monday or any other day, right? We will do it as soon as possible. Probably on Monday, be ready for it. So please revise this. You are having 2 sufficient days to do it. Tomorrow you will be having quiz for this Contract Act. 2 days still you have with you, Saturday and Sunday, and this was not a big chapter that you cannot revise it in 2 days. Still, while revision, if you face any problem, I am available on phone to every one of you, and you can call me up. You can just ask me whatever problems you are having. If you are not able to understand certain things, all the videos are uploaded. So it will not take more than 4 hours for you to just revise the entire chapter on the videos. Still you have problems, you can share with me your problems. Okay. Please WhatsApp me. You can call me anytime. Don't hesitate to call. Okay. And you are free to write anything on the group. If you have some grudges, please tell me on the group. At least I will be able to solve it and resolve it instantly, as instant as possible. Okay, sorry, you have to cooperate me for that too. Okay.
Yes, sir.
Yeah. Thank you, and thank you all.
Thank you, sir.
And have a nice
Thank you,
day to
sir.
all of you. Bye bye.
Bye, sir.